Okay, so you're at home. Delict's coming. It's almost the night before. Uh-oh. Chill out, people. I know how you feel. But relax, you know. Because Rob's here, the rap's here. And we're cruising. Ow, baby. Sorry about the techno background we're putting in here. But it's all I got on short notice, so enjoy. And learn. Of course, what else would we do? Let's kick it.
Music is off the beat.
Welcome to Delict. We have begun. The first case is Matthews versus Young. It's about some guy who sues a trade union. It's not important what is basically tuning. Is the scope of the legis equilii and the actio injuriarum, guys. The first one's for breaks to your property, and the second concerns your personality. Before continuing, here are the 4 requirements for the equilian action.
Music is off the beat.
An act or omission which was wrong, a link of causation which is strong. Fault may be negligent or intentional, and the loss must also be patrimonial. That was in Matthews v. Young. Mabasso v. Felix, the onus of proving proof in delicts. Mabasso v. Felix. Considering the onus of proof, I wish you would consider the factual, not legal issues. The defendant must prove the factual construct which justifies or excuses his conduct. Whether the conduct was actually wrong is a legal issue for the court to decide on. And this was a self-defense case. Mabasso v. Felix.
Disco music is off the beat. Disco music is off the beat.
Considering the element of wrongfulness, I know it's given me lots of stress, but it's easy if you want to spot it. Just hear what I have to say on the topic. There are 7 ways to show wrongfulness, so here's some stuff to write in the test. 1. Prior conduct or earlier actions. 2. Control of dangerous attraction. 3. Relationship between the parties brawling. And 4. A public office or calling. 5. A statute which is exact. And 6. We look at a binding contract. Number 7 is important to you and me. It's the legal convictions of the community. Because this test sums up all of those above, you see? Yo, that was the elements of wrongfulness. Cape Town Municipality versus Payne. The plaintiff, Payne, experiences pain. He hurt his foot on the stands while watching the game. That's uncool. The municipality has a duty of care to keep the stands in good repair. This was a job which they hadn't played with, and so they were liable to the plaintiff. Union Government v. Ocean Accident Guarantee Corps. Whoa, Union Government v. Ocean Accident Guarantee Corps. Back when the magistrates drove in taxis, what's more. The taxi with our man had a smash. He couldn't work, but they still paid his cash. The government afterwards tendered a plea, claiming to recover his salary from the tortfeasor whom it was found could not be liable on this ground. If the court would have let his application ride, the net of liability would be cast too wide. That's Union Government v. Ocean Accident Guarantee Corps. Administrator Natal v. Trust Bank from Africa. An expropriation of property was a big disaster.
Hate it when they take your money.
The admin thinks that B's the landowner, sends him a letter saying they want to take over. B takes the letter off to the bank, didn't tell them that its validity stank. The bank then negotiates on B's behalf. He gets paid the money and starts to laugh. The admin then finds the big mistake and sues the bank for the money at stake. It's found that no duty to investigate was ever loaded onto Trust Bank's plate. And this case is boss, showing complications involving pure economic loss. As well as making reference to negligent misstatement. Administrator Natal v. Trust Bank from Africa. Halliwell v. Johannesburg Municipal Council. The cobbles between the tram lines from hell got slippery with time and Halliwell fell. When he fell from the cart, he hurt his wrist. Stand by now for what the cart insists. The laying of the stones brought a new source of danger, and the council should have guarded like the Lone Ranger. So the omission to take these steps at last led to Halliwell's plaster cast. And this case led to the birth of the school who supports the prior conduct rule. Halliwell v. Johannesburg Municipal Council.
Hey.
Now we look at the conditions for liability from emissions. Silver Fishing Co. v. Moeza. So tell us about it, Rap. The husband of the plaintiff died. He'd been on a ship with the engine fried. They'd sent a message out for help, but Silver had let them drift with the kelp. Finally, the ship went down, and so Mweza's husband drowned. There was a duty to rescue me hearties, 'cause of the relationship between the parties. Silver's Fishing Cove, v. Mweza. Administrator of the Cape v. Preston. Cows jumped off a hill, which then compressed them. The reason for this bovine suicide was that a bridge was built on which a train did ride. The noise made by this steel creation caused the cows great aggravation. So they leaped right off this dangerous place and smashed to the earth after floating in space. And this had happened twice before, and Preston had complained what's more. They were put on notice, and so it was foreseen. And the admin had to therefore fork out the green. That's the administrator of the Cape v. Preston. S.B. Russell, the construction site bustled. He was given a warning early in the morning. The power lines would be on before long. Would he tell the others before things went wrong? He neglected to do his duty, and a crane driver fried beyond help of Moody. And Russell was under suspicion, and was guilty because of this omission. That's S.B. Russell. S.V. Fanas, 1967. A couple of kids wake up in heaven. The cops arrested their parents, you know, and so the kids froze in the snow. It was held that even a reasonable search would not have found the kids in the lurch. And so the cops' omission to scout was not the cause of death beyond reasonable doubt. That's S.V. Fanas, 1967. In Bloor v. Standard Insurance Code, Bloor's car got bust and would not go. He took it to the garage to get the new kingpins. But the people at the garage committed some big sins. They didn't report that the steering was trashed, so when Bloor started driving, his car got smashed. The prior conduct making danger, it was found, allowed the garage to be sued for not making a sound. If you want to be exact, you could also, this could have been caused by contract. It's just conjecture.
That's
anyway.
in Bloor v. Standard Insurance
Minister of
Code.
Forestry v. Quathlamba. That's where a fire broke out in a field one summer.
Minister of Forestry.
It was held that if there's a fire on your lands, you must institute reasonable plans not to let the fire spread or burn your neighbor's felt instead. The duty to control this flaming comes from the control of a dangerous thing.
That's Minister of Forestry v. Quathlamba.
Minister of Police v. Evils. This one's famous,
What?
An off-duty cop beats the crap out of Iwi. The on-duty cops all appear to be sleepy. They get sued because they shouldn't admit to prevent the crime which he did commit. The on-duty cops don't get immunity because of the legal convictions of the community.
That's Minister of Police v. Evils.
In Mkumbi v. the Minister of Law and Order. A guy's brother is regarded as a police informer.
No, I won't play this song.
He and his family were about to be deceased, and so he asked for assistance from the police. The cops came and watched as he packed up his things, but then left him alone with the vicious crowdlings. After dodging a petrol bomb, he tried to run, but the crowd came and killed him, which wasn't much fun. His wife sued the minister, and it was found that that the cops were liable, because they should have stuck around.
Nkumbi v. the Minister of Law.
Mulang v. Port Elizabeth Municipality. Mulang twists his ankle in a hole in the pavement, and he tries to sue the government. It was held that there's only a cause of action when a new danger's made and there's some new attraction. It cannot be liable for omission to construct or for dilapidation of a street, which is, So you can only sue for negligent construction, repair, or dangerous excavation.
That's in Mulang v. Port Elizabeth Municipality.
Vandermeer Burger v. Municipaliteit van Warrington was the case of damage caused by the blockage of storm water in. A furrow overflowed because it was not cleaned by the pality. And it's held that they are liable, which is a big disparity. It held that in a modern world, where they have wide resources, that municipalities should not be protected from emissions with unpleasant recourses. Now I must suggest in haste that you read Mervyn Dendy on this case.
It's Vandermeer Burger v. Municipaliteit van Warrington.
Robbie v. Kimberley, Municipality Tate. 2 cars got smashed while going through a traffic light. Both said the lights were in their favor and couldn't understand this misbehavior. The court found that it was Kimberley's error and that it was their fault that the lights weren't working better. The municipality had been made aware, but did not investigate the danger there. This omission led to aggravation and causing of a dangerous situation.
Robbie v. Kimberly Municipaliteit.
Do we want to get right?
Yeah.
Are you guys awake out there? I really do not want to be boring, so, just wake up. I gotta keep a good impression going here. Okay, next case. You ready? Right, here we are. Kruger v. Could See sets out the reasonable man test for me. A guy who's a farmer when his car hits a horse. And the horse had wandered from a field, of course. The gate to the field was left open by others, and on many occasions the farmer had scolded the buggers. He'd done as much as the reasonable man would, and so the claim of his negligence was no good.
That's in Kruger v.
And
Could
the
See.
reasonable man test goes like this. Would the injury have been foreseen? Would he take precautions to prevent this thing? Did the defendant do what he should? And if he didn't, he's negligent, and that's no good. Peri-Urban Health Board v. Munarin, where a pipe layer got totally dug in. He was working in a ditch. And when the walls caved in, it was quite a bitch. The construction company failed to ensure that the wall was safe and would endure. Remember this case because it's where the test was based on a duty of care.
Peri-Urban Health Board v. Munarin.
WITS v. Fundefenter, when an expensive racing horse got bent. The costly horse was roaming in the road. It was hit by a truck which never slowed. The driver was negligent and could not raise that an expensive horse could not be foreseen in that place. That he could expect a cheap horse was damage in kind, and the question of extent was not held in mind. You see, you only have to foresee the kind of harm that was seen from this case, which took place on the farm.
That's WITS v. Fundefenter.
Minister of Fun Politie and Binnenlandse Zaken v. Van Aswegen, a prisoner escaped from the policeman. The prisoner's hands were cuffed in front of him, and he sat in the back, but then grabbed at the steering. The cop car went wild and smashed with a truck filled with animals, including a duck. The policeman ought to have foreseen the escape. It didn't matter how or the form it would take. In failing precautions to prevent this dude, the Minister van Politie got screwed. I don't know if it makes much sense, but this case adopts relative negligence.
I can't pick that up. Minister van Politie en Binnenlandse Zaken v. Van Aswegen.
Murray v. Union in Southwest Africa Insurance Co. Poor old Murray was in a hurry. As he rode upon his bike, he caught an eyeful of carbon dust as a bus pulled off from the light. The kind of damage was not foreseeable, and so to find him negligent was unfortunately not agreeable. And referring to the bus driver there.
And that was Murray v. Union and Southwest Africa Insurance Co.
Smith v. Leachbrain & Co., where some galvanizer gets quite a blow. Some molten metal hits him on the lip, which triggers a cancer, which lets rip. 3 years later, the dude is dead, and his wife sues for Leachbrain's head. His lip had a pre-malignant tissue, but with the thin skull rule, that wasn't an issue. He could have foreseen the kind of injury, and so for the full amount is his liability.
Smith v. Leachbrain & Co. I wonder if he could kiss well.
In the case of Wilson v. Burt, a pole falls from a guy, or a pole falls on a guy's head, which gets hurt. The chap in question had just been stabbed and operated on his head, which was bad. Since the pole hit him on the top, he got epileptic, which made him drop. In terms of the weak heart, thin skull rule, the kind of harm was foreseen in this school. He was compensated as such, you see, for the bouts of epilepsy.
That's Wilson v. Burt.
Kruger v. Fonda Merva. An oncoming car had to swerve because the defendant was overtaking. The approaching guy started braking. The car behind him hit his rear, and into a ditch he did career. It was held that the overtaker should have foreseen that the car behind the crashee's brakes were not so keen.
And Kruger
Get out, draw a picture.
Yeah, Kruger v. Van Merva.
Stans v. B. Troman. That's where some guy got robbed at home. Oh, they robbed his home, man. An interior decorator left the door unlocked. Now when the owner got back, whoa, she was shocked. Plenty of stuff had just been stolen, but for his money the decorator was moaning. The owner then did counterclaim, and this is what the court exclaimed. The guy was under a duty to guard against what went down. So a novus actor intervenience could not be found. And accordingly, said the judicial boss, the director is liable for the householder's loss.
Stansby v. Troman.
General Accident Insurance Co. v. Xejo. Yo. The situation causing all the fuss was some petrol bombs thrown onto a bus. Some of the passengers got a little fried, so suing the bus co is what they tried. Was held that the violence the previous day should have warned the driver to stay away. The precautions taken by the owner were not sufficient, and so he was negligent. That's General Accident Insurance Co. v. Xejo. Smith v. Abrahams, where a hawker's vending van gets trashed by a negligent driver. Though the hawker is a survivor, he has to hire a new vending van because he's a really very poor man. It's held that the driver should have expected the poverty of the man with whom he connected, and thus he had to pay for the damage to the cart, as well as for hiring a new one from which to start. That's Smith v. Abrahams. Smith v. America v. Union Government. This is a motoring case which will tell you that we don't live in a utopia. The reasonable motorist must expect that other drivers are deviant at best. So let's stay away from those taxis out there.
Too sexy for my
Van America v. Union Government. Moore v. the Minister of Posts and Telegraphs. Basically says you must expect a few laughs when watching other drivers who are usually more negligent than you by far.
Moore v. the Minister of Posts and Telegraphs. Whoa, techno.
Marine and Trade Insurance v. Singh is the case where a guy from the bus door did swing. Since the last stop, the bus door was open. He jumped for it while the bus was in motion. The driver, they say, should have expected that a lunatic like this would be projected through the air and off the bus door, eventually residing on the floor, where the front wheel of the bus drove over him. So this case says we must anticipate that from the law people will deviate. The following cases determine the alarm that the reasonable man would experience in foreseeing the harm.
The last one was Marine and Trade Insurance Co. v.
Herschel
Singh.
v. Mrupe, where an old woman was stupid. She made a mistake as to who was the insurer when a bus killed a man, which was a big bruiser. Later they discovered her mistake, but new legal costs were now at stake. But she could not have seen that her misstatement would lead to the incorrect cost. In statement.
Get it right,
Yeah.
Rob. Get it right.
She couldn't see that her misstatement will lead to the incorrect cost in statement. That makes sense. So
Okay.
because she needn't foresee the cost, in this case the plaintiff lost.
That's in Herschel v. Mrupe. It's getting late, okay?
Wasserman v. Union Government. Wasserman was asked by a policeman to see if he could locate a bunch of bees. He found the bees, but oh too well, they stung his lip, which began to swell. A normal man would have survived, but he was allergic, and so he
This
died.
guy couldn't kiss either. Wasserman v. Union Government. Oh, there's still more coming.
A duty to protect against hurt arises only where the reasonable man would realize it and be alert. The existence of the bees was an ordinary risk, and so he need not protect against this.
That was Wasserman v. Union Government.
In Bolton v. Stone, a cricket ball was thrown to a batman who hit it with a really great sound, after which the ball flew out of the grounds. It hit some poor guy straight in the eye, and he started to cry that fence wasn't high enough to look after his head. But this is what the judges said. Though the damage expected was quite great, the chance of it happening was not an expected trait. And what I'm telling you all is that the magnitude of risk was small.
Bolton v. Stone.
Lomagundi sheet metal v. Basson. Some guys were welding on a roof, you see, and underneath them were some bags of mealie leaves. One of the welders got excited, and so the stover was ignited. Though the chance of this happening was small, the prospective damage would be to destroy it all. So
That was
it was
Lomagundi.
held that they should have taken the time to move the mealies out of line. It's a lot of fun, because that's what the reasonable man would have done.
Lomagundi sheet metal v. Basson.
Robertson v. Durban Turf Club, where a horse gets pissed off and demands a back rub.
Nay.
The stupid beast goes and throws her rider, then falls and dies in a ditch beside her. This ditch was made safe for a normal horse, but was not designed for a rodeo course. The cost of prevention was far too high, compared with the probability, guys. The risk was balanced, as they say, and so the diggers got away.
It's Robertson v. Durban Turf Club.
Is anybody still listening to this?
I'm listening to this.
I guess it's appropriate, even if it is techno like this.
The music, he means. Next case.
In Funfake v. Lewis, the surgeon blew this. After slicing the babe a little wider, he left a surgical swab inside her. The patient naturally wanted to kill, and so this case is one involving expert skill. Did the surgeon make a mistake? Or what would make this case make or break? He had to act as well as his peers, as experience had showed him through the years. The theater sister should have added the swabs and bits of body that were padded.
1, 2, 3.
And so, because he acted as he should, the surgeon got off this rap for good.
Funfake v. Lewis. Out here, he means, there, relax, chill.
Bulls beat Satsarilakis, deals with a wrist, not just with a carcass. The guy goes to a provincial hospital. He's hurt his wrist and is not well. The doctor there takes some x-rays, says you're fine, come see me in a couple of days. A radiologist agreed that everything was jacked, but within a few days this guy was back. The swelling had gone down a bit, and so he was sent away with some moody for it. The dude then goes to a specialist who in turn x-rays the wrist again. He finds a reason for the guy to moan, a fracture of the scaphoid bone. The doctor is sued for being skillless, for pain and suffering, and because his treatment was useless. The court said the doctor had been okay, and this is eventually what saved the day.
Bulls beat Satsarilakis.
The Brain v. Minister Fun for Four appears under 2 headings this year.
So look for it later.
A 6-year-old was hit by a car as it passed. The driver was negligent and going too fast. The court also asks the following. Besides that, did he see that the kid was around? Or was it reasonable that one would be found? If these facts were true, then it's not deniable that he is negligent and therefore liable.
The Brain v. Minister
And
Fun
this
for
case
Four.
is also dealt with later with regard to contributory negligence of children.
Whoa, this music is terrible. If you guys hate it as much as I do, my humble apologies, but hey, we gotta get it done somehow.
Can't wait for the weekend. So do you love me or what?